This is the time set for oral argument in Pennell versus Southwest Gas, our cause number 1CA CV12-0620. Counsel, as you're aware, we've already conferenced this case, read the briefs. We're quite familiar with the record, so you can bear that in mind as you begin your presentation. Also, probably a first for each of you, we are now videotaping these arguments and making them public. So if you'd announce your name and that of the client you represent when you approach the podium, it'll make the recording that much clearer. Each side has 20 minutes for oral argument, and for the appellant, the amount of time left on the clock when you sit down is the amount of time you have left for rebuttal. With that, we can begin.
May it please the Court, Timothy Berg of Fenimore Craig on behalf of Pennell Energy. At bottom, this is a dispute over whether the Superior Court or the Arizona Corporation Commission has jurisdiction to interpret an agreement whereby Southwest Gas promised to build a pipeline in order to provide service to Pennell Energy, and Pennell Energy agreed to pay for that pipeline through agreed-upon charges. Under the well-settled law of the state and the policy underlying that law, a dispute over the interpretation of and possible breach of an agreement belongs in the courts and not at the Commission. The issues that really remain to be resolved, and they're in dispute between the parties, are traditional common law contract disputes that courts are best equipped to decide. What does this agreement mean? Did Southwest Gas promise to use all commercially reasonable efforts to build the permanent pipeline by a specific date? If they failed to do so, what's the impact of that failure? Were the Type A charges paid by Pennell Energy to Southwest Gas intended by the parties to recover Southwest Gas cost of building the facilities, including the permanent pipeline, and to be payment for building that pipeline? If the agreement required Type A charges to be trued up after construction was completed on the permanent route, can Southwest Gas retain a windfall by simply failing to build that route? If they do so, does that violate the covenant of good faith and fair dealing? None of those issues are regulatory issues within the jurisdiction of the Arizona Corporation Commission or about which the Arizona Corporation Commission has any particular expertise. This is simply a dispute between parties over the meaning and whether or not there's been a breach of a contract that was entered into between the two of them.
How do we square your comments with count 3 of the complaint?
Your Honor, it is clear to me that count 3 of the complaint falls less within that realm than counts 1 and 2. Counts 1 and 2 clearly relate to the breach of the contract or the breach of the covenant of good faith and fair dealing. To the extent that the trial court dismissed count 3, which asked for a determination of our status as a particular kind of customer, we would concede that that was probably a correct ruling. But the counts 1 and 2 belonged in the Superior Court because they're basically contract claims or covenant of good faith and fair dealing claims.
So, and again, I don't want you to make any concession you're uncomfortable with, but let's say we agree with everything you've just said, but we find that count 3 really is problematical. I take it then your client would certainly not be too upset with having a remand on count 1 and 2, and we would affirm the judgment on 3.
That would certainly, yes, that would be the correct remedy, I believe, Your Honor. The question of whether we're a particular kind of customer is less clearly contractual than the first 2 counts.
So where do you fall even within the ability to negotiate as part of under the B1 tariff? That possibly could be within?
I don't think so, Your Honor. I think the question of whether, for example, we are a certain kind of customer today, which is what I take count 3 to be asking for a declaration of, is closer to a regulatory issue than the other 2 issues are. The first 2 issues are clearly, one, has Southwest Gas breached the construction agreement by failing to build the pipeline, by failing to use its reasonable commercial efforts to build the pipeline, and by retaining our money, and concomitantly have they violated the covenant of good faith or breached the covenant of good faith and fair dealing by doing that. If you take Southwest's position at its bottom, the way they would argue this is that we're in a position where we pay them this money, they never have to build the pipeline, and we have no remedy. And that can't be the right answer here. ultimately, it's hard sometimes to keep the merits separate from the jurisdictional issue. But I think if you look at the things that really need to be litigated on the merits here, it's what does that agreement mean? What are they obligated to do? What were we obligated to do? What is our remedy, or what did the contract obligate parties to do under certain sets of circumstances? The governing document here is the construction contract, not the B1 tariff, not the transportation agreement.
Well, in any event, do I understand your position to be that the rates that the rates that were negotiated in the B1 tariff are the rates? This is not a question about what the rate should be.
Absolutely, Your Honor.
Or whether the rate's permissible.
It is not a question about whether these are just and reasonable rates within the meaning of the Arizona statutes and constitutional provision governing the Corporation Commission. The question is, did we pay them for something they agreed to do that they then failed to do? And where the contract provides a remedy in the form of true-up, can they essentially deprive us of the benefit of that remedy by simply never performing at all? Their argument essentially is, we have an agreement, it provides for us to build something, it provides for us to true up the costs at the end. If we never build anything, you don't get a pipeline and you don't get a true up of your costs, you're just out of luck. And that can't be the right answer. That can't be what that contract means. Obviously, you all don't need to decide what that contract means. All you need to decide is who decides what that contract means.
And if the decision is that there was a breach of the contract and that the remedy should not be that the permanent route is ever built, does the contract provide a clear means of computing damages?
Yes, it does. I believe it does, Your Honor, because it tells you, if you go to Exhibit B to the original agreement and revised Exhibit B to the addendum, it tells you how to calculate essentially the damages. The damages would be, we would be refunded actually in the case in which they don't build anything, pardon me, I tried to make that more complicated than I needed to. We're simply entitled to have all the money we paid them for construction in the form of Type A charges returned to us. Those are the damages for breach of contract in this case. If they were to have built something but not finished it, then you would have to go through the Exhibit B to the two contracts and figure out what we owed them, what their costs were, and what we didn't get back. It's important to note the agreement actually contemplates this sort of thing. If you look at the agreement itself, the construction contract, there are 3 or 4 different places where it becomes clear that what we were paying them to do was build the pipeline. First, there's the true-up schedule on Exhibit B and revised Exhibit B, which provides that if the construction cost is greater or less, that changes what the Type A charges are so that they get to recapture their cost of building, or we get the benefit of it being a lower cost of building. Second, we were required to provide them with a letter of credit. And we would provide them with a letter of credit in the amount of $4 million, which was the cost of building the permanent pipeline and the other facilities at the time they started construction of the permanent pipeline. Again, that indicates that the purpose of the agreement is to get the pipeline built. Third, there's a termination provision in the contract, and this is Article 3 of the agreement and addendum, which provides that after a certain term, I think it's at the end of 10 years in the original agreement and 11 in the addendum, we have to give them notice ahead. We can terminate the agreement, but we owe them whatever remains unpaid on the construction costs. Similarly, Article 5G of the agreement permits Pinal Energy to decide not to finish building it, not to build its plant or to complete the plant and go into operation, and what they have to pay Southwest Gas at that point, had they done that, was the unrecovered construction cost. If Southwest Gas had started building the pipeline and Pinal Energy had said, this is sort of the General Cable case, you start building the pipeline, the company decides they're not going to go into business, this agreement provided a remedy. What we had to do then was pay them the unrecovered portion of their construction costs. Again, the whole purpose of the construction agreement and addendum and the addendum that amended the construction agreement was to get a pipeline built, to have them do it, to have us pay them, recognizing that the cost in the agreement was an estimate, to have that cost trued up eventually, so that if it cost them more, we paid them more. If it cost them less, we got the benefit of the lower construction costs. Those are simple, common law, everyday contract interpretation issues. And there's no reason to defer to the jurisdiction of the Arizona Corporation Commission. To cover a couple of other points quickly. One, it's obvious that if the commission has no jurisdiction over this dispute at all, it can't have primary jurisdiction over this dispute. And that takes care of the judge's alternative ruling. But even if you assume some sort of concurrent jurisdiction here, because the contractual interpretation issues prevail over any regulatory issues, what do the tariffs mean? It would be an abuse, it was an abuse of discretion, pardon me, it wouldn't be. It was an abuse of discretion for the trial judge to find primary jurisdiction in the Corporation Commission. Just as the commission doesn't have exclusive jurisdiction, it shouldn't have primary jurisdiction.
Just in the abstract, what would be a case in which the court and the commission would have concurrent jurisdiction? I can't figure that out. Because it
is kind of an interesting one, Your Honor. I suppose that if you had a dispute that was a contractual dispute, and the dispute between the parties turned on some issue or rate that had been set by the commission in the first place. Let's say, for example, you and I enter into a contract, and we agree to pay rates that from time to time the commission sets. And you want to sue me and claim somehow in the course of the commission's rate being set, something went wrong and I overcharged you under the contract. If there were an issue about whether the rate the commission set in the first place were correct, maybe you go to the commission first and then you come back. The only cases really dealing with primary jurisdiction in the commission context that I'm aware of are both Quest cases. I actually handled one of them, are Campbell and the Kelly, I'll call it the Kelly case, because John Kelly, the judge, was the nominal respondent. And in both cases, the court found there wasn't primary jurisdiction in the commission. So there's not really a case out there that tells you when it would apply. The last point I want to cover, and then I'll save the rest of my time for rebuttal, is the attorney's fees issue. Obviously, if we're right and the dispute belongs in the Superior Court, then the attorney's fees award should be vacated anyway. But Southwest Gas' position on attorney's fees is kind of an interesting example of wanting to have your cake and eat it too. What Mr. Grant will come up here and tell you is this is a regulatory dispute. It's a dispute about tariffs. It has to do with what the commission did. This is all in the jurisdiction of the commission. It's a regulatory issue and not a contract issue. But of course, we're entitled to our fees because this case arises out of contract. I suggest to you that the two conclusions are completely inconsistent, and the trial court got it wrong at the very least when it awarded attorney's fees in this case.
But don't we have quite a bit of case law that says when a party shows that a contract does not exist after the other side has said it did exist, that implicates 12-34101?
You do, Your Honor, but again, this isn't that case. Mr. Grant isn't arguing that there is no contract here. He's saying the contract is subject to the commission's jurisdiction, not the court's jurisdiction. This isn't a case. Had we taken this case to the end, and Mr. Grant proved he didn't breach it, then he may well, taken it all the way through the court, proved he didn't breach it, he would be entitled to fees.
I guess what you're saying, this is more similar to the line of cases that says that when the matter is an administrative matter, the contract statute doesn't apply.
Absolutely. If Mr. Grant is right, and I don't for a moment concede that he is, then this is an administrative matter and there's no statute that would provide for an award of attorney's fees there. I'll save the rest of my time for rebuttal. Thank you.
Thank you.
Judges, good morning again. Mike Grant of Gallagher and Kennedy on behalf of Southwest Gas. I'd like to take just a couple of minutes to briefly summarize our view of the case. About 100 years of very consistent, I think very clear, constitutional and statutory language as well as case law dictate that this is a rates, tariffs, contract dispute entrusted exclusively to the Article 15 jurisdiction of the Corporation Commission, but as importantly, subject to the constitutional right of either Pinnell or Southwest Gas to appeal the matter to the courts if the Commission mishandles the matter. Pinnell Energy's complaint asked the Superior Court, not the Commission, to determine the reasonableness of rates it has been charged for gas transportation service under a contract negotiated pursuant to a Commission-approved tariff, whether an overcollection of those rates has occurred, whether a refund or a rebate of those rates is appropriate. If so, how big that rebate should be. And finally, how Pinal should be classified as a gas customer going forward. Trial court, based on those allegations and requests, correctly concluded that the core nature of this dispute is about bypass transportation service and the reasonableness of the rates charged for it. Therefore, all of those matters need to be decided by the Commission. Alternatively, the trial court concluded the primary jurisdiction doctrine also supports Commission processing of the case. That ruling is reviewed on an abuse of discretion standard. Those trial court rulings, fully consistent with the Supreme Court's and this Court's conclusions in several cases, including the Court of Appeals APS v. Phoenix decision that, number one, only the Commission can determine an overcollection, and number two, it's also within the Commission's exclusive jurisdiction to determine if a refund obligation exists. Now, to try to avoid that result, Mr. Berg and Pinal Energy want to turn this into a construction contract dispute. Pinal's problem is it's not a construction contract dispute. Cleanest, simplest way to demonstrate that is if Pinal had actually wanted to build a miles-long pipeline linking the El Paso Interstate Natural Gas Pipeline directly to their planned facilities, they would have gone to a general contractor and signed a construction contract. At the risk of stating the obvious, Southwest Gas is not a general contractor. Instead, Pinal came to Southwest Gas. Why? Because they expressly did not want to build a bypass pipeline. What they wanted was to use the possibility of then building the pipeline to get cheaper natural gas transportation rates from Southwest Gas. And incidentally, by using the Commission-approved tariff B1, they succeeded at that quite profitably. By using that Commission-approved B1 tariff, they negotiated a discounted rate for gas transportation service of only about 8 cents a therm. That's about half what Pinal would have otherwise needed to pay for transportation under the standard Commission rates.
You know, as I understand that the cases that explain the exclusive jurisdiction of the Commission, the general principle is that the Commission has the exclusive jurisdiction to determine rates, to set rates. But as I understand the situation here, assuming Pinal is a qualifying customer, then the B1 tariff allows the parties to negotiate rates. And those rates have been set, if you will, in the contracts.
Correct, Judge.
So I don't understand how this dispute implicates the setting of rates. I understand this dispute is about whether rates need to be paid and have they been overpaid or underpaid. So help us understand that.
Well, Judge, it's a situation that candidly, with that El Paso natural gas pipeline coming in southeast part of the state, winding its way to Tucson, coming up to Phoenix, and then heading where it really wants to go, which is to the big state of California. This is a situation that will occur quite frequently because there will be a number of businesses and industries within striking distance of that El Paso natural gas pipeline that could build to it, could bypass the local utilities service and get service directly. In that instance, the utility involved, in this case Southwest Gas, and its other customers, residential and commercial customers, lose the benefit of whatever contribution would have been otherwise made by this customer to Southwest's costs of doing business. So the Commission can't know how many miles away the pipeline is going to be, what the demands of the customer are going to be. So it can't set a rate. And I think what you and I normally think of as the normal way. Okay, if you want residential service, it's 25 cents per therm, or it's 50 cents a kWh. What they do with a bypass tariff, though, like B1, is they bound the negotiations. They specify, and there's about 7 or 8 parameters that the Commission says, okay, you can negotiate to the rates, and those rates will become
Right.
the just and reasonable rates. If you do that, then you have moved pursuant to a commission-approved tariff, and the result produces rates that are authorized by the commission. And in this case, that's precisely what was done. The reason the pipeline, building a pipeline, comes into this discussion is because one of the criteria the commission states is, well, you're going to give that bypass customer a discount from the transportation rate, but it has to be measured by the value of service to you, the customer. Well, in this case, it was thought another pipeline was going to be necessary just to provide service, but it was going to provide the way for the parties, and for that matter the commission, to measure the value of that service. If you go to Exhibit B of the agreement, I think it is, it sets out a number of different hypotheticals on what the cost of that pipeline might be and what the rate result would be. Well, what that's really doing is it's measuring the value of the service to Pinal. In other words, it's saying, Pinal, if ultimately when this pipeline gets built, incidentally, the agreement's very clear that those are matters solely entrusted to Southwest Gas discretion, then I think the bogey in the contract, with the estimated construction cost, was $3.8 million. If, for example, the construction cost of that agreement was to come in at $5 million, then they have avoided more costs than they were given credit for, and you'd have a rate reduction. If it comes in at, say, $3 million, then the discount off the standard transportation rate would need to be greater. And all of that taken together, Judge, I hope answers your question.
Well, I'm still puzzled because what I understand the contracts to do and is to, and your explanation kind of reinforces this, I think, is that the parties have set the rates. They've accounted for a lot of possibilities, the true up being the bottom line possibility. And since the parties have set the rates themselves, how is the ability of the power of the Corporation Commission to set rates implicated here? What would you expect the Corporation Commission to be able to do in this case? Would if this were before the Commission, would Southwest Gas argue that the Commission has the power to void the contracts and impose a different rate?
I think that would be one of the possibilities available to the Commission. If it feels that any of these 7 or 8 criteria in the bypass tariff, which authorize the service in which the parties negotiated to, are unjust, unreasonable, then the Commission would, in that case, determine what would be an appropriate rate. I can tell you what would not occur is that by asking for and this is exactly what the plaintiff's complaint asked for, it asked for rebate of all amounts paid. It's a matter solely entrusted to the jurisdiction of the Commission by this court's jurisprudence. They ask for basically the court to determine what the rate should be, how much of a rebate there should be. That's entrusted to the jurisdiction of the Commission.
Isn't that just another word for damages?
Well, but it's damages. I'm sorry, Judge.
No, you go ahead.
It's damages, though, measured by rates terms. That's why the case law fences that off and says, no, that's a matter to be left to the Commission.
I've been listening very intently, and I've reviewed your briefs very closely. And I was struck that when you began your remarks, you were making, actually, I thought, the same points that Mr. Berg made. But instead of talking about charges, you used the word rates. And I have the sense that we're in this, a rose is a rose is a rose. You want to call it rates because that sounds more like what the Corporation Commission does. Mr. Berg and Pinal Energy want to talk about charges. But when I look at the heart of what this dispute is all about, it is what did these people, your client and Pinal Energy, what did they agree to do? Did one side or the other perform or not perform, and what are the damages? And this strikes me that these are quintessential issues of contract law that require the court to also interpret the contract, which is another quintessential task that trial courts do every single day. And so I'm having a hard time, and I think I'm building on Judge Johnson's question, understanding, well, what would the Corporation Commission be doing with this type of dispute?
Well, I think one of the things that Pinnell has done very well here that throws you off the beam, and incidentally, it can be called a charge or it can be called a rate, but they're trying to make it appear as if it's a charge for building a pipeline. It's not.
Well, there was
It
a
is a
construction
charge.
contract.
I'm sorry?
There was a construction contract.
There was a construction contract, Judge, although it vests in Southwest Gas.
Well, perhaps.
The
but Pinnell
total
has sued
discretion
for
as to
the
where.
breach of that contract.
But Judge, the purpose for the construction of it, and the permanent route may still be built, was to true up the charges for transportation by Southwest Gas of volumes of natural gas. That is, and those charges are what are exclusively in the domain of the Arizona Corporation Commission.
Well,
If you want to challenge them as
Pinnell has cast its claim as one for breach of a construction contract. You may disagree that it has such a claim. Isn't the risk that Pinnell takes losing if there's no such breach? I mean, that's really the remedy. If they want to base this on a construction contract, trial court has jurisdiction, and if you convince the trial court that there was no breach of a construction contract, then you simply win. But I don't see why it is that the plaintiff can't decide what kind of action it wants to bring, if any.
Well, Judge, I think the reason why they can't decide it in this context is to call it reimbursement to Southwest Gas for a construction activity, when it is not. It is indeed a request for damages parading as a rebate or a refund of the charges for service charges for transportation of volumes of natural gas. That pulls this to its core nature, which is a rates dispute, a refund dispute, a rebate dispute entrusted to the Commission's jurisdiction.
I'm not sure that quite gets to it. I mean, again, you're trying to characterize the case as something other than the plaintiff, and if it turns out that this is simply a dispute over rates, which I'm having difficulty seeing, but if it turned out to be the case, then that would mean that there was no breach of the construction contract, that this was more a policy matter for the Corporation Commission. But they've claimed that there's a breach of the construction contract. Whether there was or wasn't, the question is who gets to decide that. And when you claim that there's a breach of a construction contract, I don't see anywhere that the Corporation Commission gets that case.
Well, Judge, let me go to the Quest v. Kelly decision. There, if I recall the facts of that case correctly, the court found that the court understandably had tort jurisdiction over alleged misuse by the phone company of a tariff. Perfectly understandable result. But the court stopped short when you got to the allegation of, well, you ought to give us some portion of the money back. The court said, no, that's exclusively within the jurisdiction of the commission to determine a refund or a rebate. There's, as we have cited in our pleadings, there is a long line of those cases saying, no, these are matters entrusted solely to commission jurisdiction, and what they're doing is they're attacking the rates established pursuant to a commission-approved tariff and consistent with the jurisprudence of the Supreme Court in this court, says that goes to 1200 West Washington, not the court.
This may sound like a bizarre question, but let's say that you've got a customer, a commercial customer that's contracted for natural gas services, and Southwest supplies natural gas. Suddenly, the stuff in the pipe that it's supplying is pure nitrogen. It's non-flammable. There's no energy coming through it, but the flow is there. And then it turns into pure hydrogen, and it becomes very dangerous, and damages result. If Southwest Gas is sued for that failure to perform the service it contracted to perform, either because the gas was useless or because it was dangerous, I take it you'd concede that the Superior Court has jurisdiction over at least some portion of that claim.
Absolutely. That's basically Quest v. Kelly.
Right. And so if a portion of the damages in that claim are a return of money paid for the useless product, does the Superior Court have jurisdiction over that?
Judge, I think the answer to that is yes, because in that case, as I understand your question, and I hope I do correctly, the rate or the charge is merely being used as a measure for the court to make a determination as to a damage element. Here, they actually want the rates back. They want the rates back, which were paid for natural gas transportation service.
And that goes to the question I asked Mr. Berg, which was, does the contract itself provide a clear remedy or a clear path to a computation of a monetary remedy in the event a breach is found? He seems to think that it does. Are you saying that it doesn't?
I don't think so, Judge.
What would the court have to do to fashion a remedy in the event it found a breach?
You would, the commission, in the event that it found a breach, it would undoubtedly be going to the nature of the service, the requirements of the B1 tariff, in measuring the measure of damage against those, basically those two touchstones. And that's how they deal, if the allegation of a service breach was correct.
But isn't then the court simply making a computation based on data obtained by rate setting, not actually setting rates?
Well, the case law indicates that when you instruct someone to return the money that they have paid in rates, that's a refund or a rebate. And the legislature has very expressly said in ARS 40-374 that is a matter solely entrusted to the jurisdiction of the commission.
But in my nitrogen case, if I ask for the return of money I've paid because you sold me the wrong stuff, and those are rates I was paying, and I asked for the return, the court has jurisdiction over that, you believe?
Well, because again, Judge, at least I interpreted your hypothetical to be it was a measure. It was not it was a measure of the damages accorded, right, as opposed to being actually a return of the rate. If it's a return of the rate, I think it would return us to the same spot.
Does the Corporation Commission approve the rates the parties negotiate under a B1 tariff? Is there a process by which those are placed before the Commission and blesses it?
No, they authorize the negotiations under B1. There is no requirement that the contract be filed with the Commission. Okay. The Commission makes, as you can imagine, there would be a lot of contracts filed. And they, I think, leave it to the parties in this instance to, if they feel that there is a problem, they can bring that matter to the Commission and challenge it in that way.
Okay.
I see my time has expired. I'm happy to continue to talk, but I know you sometimes adhere to the clock.
Other questions from the panel? We'll release you and appreciate.
We appreciate it. Thank you.
Very briefly, Your Honors. I think you see where Southwest Gas position takes you by the last few things Mr. Grant said. What he said is there's nothing wrong in Judge Swan's hypothetical with refunding the money to a customer that's bought gas that either damages it or is not existent gas, but you can't refund the rate. You can measure the damages, by the rates. You can give them exactly the same amount of money, but if you call it refunding the rates, then it's in the commission's jurisdiction. I suggest to you that's a sterile distinction. In our case, we'd be perfectly happy to have damages measured by the amount we paid them, and we don't care what happens to the rate so long as we get our damages. It's a meaningless distinction. And the reason it's a meaningless distinction is that Mr. Grant misunderstands the Quest versus Kelly case. In Quest versus Kelly, Quest was sued, and to my eternal lack of happiness, I know this because I was on the losing side of the case. Quest was sued for consumer fraud, unjust enrichment, another tort theory, and a statutory claim that the rates weren't just and reasonable within the meaning of Title 40, which is the Arizona Corporation Commission statutes on rates. What happened was Judge Kelly was that the plaintiffs actually agreed to dismiss the statutory claim as within the jurisdiction of the commission, and the question that went up to the Court of Appeals was, what about the unjust enrichment claim? What about the consumer fraud claim? What about the tort claim? The court held that the courts had primary jurisdiction over that and could proceed to get back their money the same way they could in Judge Swan's hypothetical, because they paid for something that allegedly Quest hadn't provided to them. It sold them inside wire maintenance for wire that was owned by their landlord and not them, was the nature of the claim.
Didn't the court hold that the commission had primary jurisdiction, so it,
No, in the Quest case,
Back and reread it, I
in the
think.
Quest
Yeah,
case,
okay.
the court held the commission had neither exclusive nor
Oh, okay,
primary
that's- okay,
jurisdiction.
that's right, yeah.
Believe me, if I'd one part of the case, I'd
Oh,
remember.
you would remember, that's right, okay.
Really, Mr. Grant tells you that Exhibit B to the agreement measures the value to Pinal Energy and not the construction costs. I take you back through the agreement. There are 4 different schedules. Schedule B, the schedule that deals with the letter of credit, the schedule that deals with our right to terminate the agreement, the schedule that deals with our right to stop construction. In each case, what do we end up owing Southwest Gas? We owe them the construction charges. Why? Because that was what they were contracting to do, and if they spent some money doing it, then if we wanted out of the agreement, we ought to pay them for it. At bottom, Your Honors, this is a plain vanilla contract dispute. We've alleged that we entered into a construction contract with them. We allege they promised to build facilities. We allege that at the end of the construction of those facilities, we were permitted, they were supposed to true it up and make it right for us. We've alleged they breached that contract. We've also alleged that concomitant to that contract was a covenant of good faith and fair dealing. We've alleged they've breached that. Mr. Grant is entitled to go into Superior Court and prove that he didn't breach the contract, even argue that there was no agreement if he wants to. But the question before you today isn't do we win a breach of contract suit, it's where does that breach of contract suit belong? And under the well-settled jurisprudence of this case, including the Trico case, the General Cable case, the Quest versus Kelly case, these are traditional contract issues that should be litigated in the Superior Court of Arizona. We ask you to enter an order reversing and remanding the order entered by the, reversing and remanding the judgment, vacating the award of attorney's fees against us, and remanding this matter to further proceedings in the Superior Court.
May I ask a question about this? Because you've just emphasized the construction nature of the contract, and that is definitely a motif in the pleadings and in the briefing on appeal. Is it really that critical that this be viewed as a construction contract? I mean, in a sense, what your client bought was the transportation of gas. Now, to get that gas, there needed to be a pipeline. So as part of the overall deal, Southwest agreed to construct a pipeline. And there's no question there's a dispute over did it perform, did it not perform, did your client ask them not to do that? I mean, there's all these disputes about all of this. But at its basic, isn't this really where your client wanted the transportation of gas? And in order to do that, there's a construction feature and there's also the transportation feature. It's all kind of one big package. So is it really critical for us to characterize this as a construction contract?
Your Honor, I think whatever kind of agreement it is, the question of the interpretation, validity, and breach of that agreement belongs in the Superior Court. I think if you look at some of the cases, like the Trico case, that's an agreement that in the end of the day had to go to the Corporation Commission to be approved, because it was a sale of utility assets, and there's an Arizona statute that requires you to do it. And the Supreme Court still held the question of the validity and construction of that contract belongs in the courts. The commission may have to review the transaction at the end of the day to decide it was in the public interest. But the question of what the contract means is a court question. I think that's the same case here, no matter which way you characterize this contract. We really think it's a construction contract. We think we contracted to get built a pipeline that we could have gone out and gotten built by somebody else. We could have built that pipeline, gone directly to the El Paso pipeline, and bypassed Southwest Gas completely. Instead, Southwest Gas came to us and said, we'll build you the facilities, we'll provide you with the service. And the question of what the contract and arrangement we entered into with them means is a court question, not a commission question.
One last question, and I don't know if this is pertinent to the case, but it's something that I couldn't quite figure out. Your client is paying for transportation charges, but does it pay El Paso for the gas itself? Is that a different?
Let me explain to you how this works. We buy the gas at the wellhead.
Right.
We pay El Paso to transport it on their interstate pipeline to the point at which it goes into the Southwest Gas pipeline to be delivered to us. We pay Southwest Gas 2 charges. We pay the Type A charges, which were to reimburse them for the construction, and then we pay them the Type B charges, which no one is disputing here, for the actual gas that comes into the plant.
Okay, that's what I thought, okay. Okay.
If you all have no further questions, thank you very much.
All right, thank you. Thanks to both counsel for their arguments, very helpful. This matter is now under advisement. We'll issue a written decision in due course, and we stand adjourned.
Yeah.
17-inch
Yeah,
laptops.
well, that I can't imagine.